For those of you who don't know me, my name is Ira Smith, President of Ira Smith Trustee and Receiver, Inc. First, we hope that you and your family continue to be safe, healthy, and secure during this COVID-19 pandemic. I want to assure you that the Ira Smith team is fully operational. Both Brandon Smith and myself are holding telephone consultations, telephone conference call meetings, and video meetings. So if you have any questions at all about this blog or anything else, feel free to either shoot us a message or give us a phone call. We would love to hear from you. We noticed over the last couple of weeks that there's been a lot of online searches, an increase in online searches for the term bankruptcy trustee. So Brandon thought, given that increased interest, he would do a general blog on the kinds of questions we are asked about being a bankruptcy trustee. So I hope you can watch until the end of this video, because I know you will get value from it. What is a bankruptcy trustee? Well, firstly, bankruptcy trustee is the old name. It's what we used to be called. The new name, authorized and mandated by the Superintendent of Bankruptcy, is a licensed insolvency trustee. What a licensed insolvency trustee is, it is the only professional in Canada licensed, authorized, regulated, and supervised by the Government of Canada through the Office of the Superintendent of Bankruptcy in order to carry out insolvency assignments. These assignments could be trustee of a personal bankruptcy, corporate bankruptcy, trustee under a restructuring proposal, an administrator of a consumer proposal, or acting as a receiver, receiver manager, or as a monitor under the Companies Creditors Arrangement Act. In order to become a licensed insolvency trustee, first, you need to get employment with a qualified licensed insolvency trustee firm. Then you take a series of courses that are operated by our national association, the Canadian Association of Insolvency and Restructuring Professionals. When you've passed the exams, including the final exam, then our association will give you the designation of Canadian Insolvency Restructuring Professional, CIRP. Then you can apply to the federal government through the Office of the Superintendent of Bankruptcy to sit an oral exam before the Oral Board of Examiners that is run by the Superintendent's Office. You have to go through a qualification process. You have to have your CIRP. You have to have also passed the National Insolvency Counselor course. You then get vetted. It's an RCMP check to make sure you have good character, you do not have any criminal record, that you are solvent. And then you sit before the Oral Board of Examiners. The board then decides whether you have met the requirements to get awarded your licensed insolvency trustee designation, your license, and makes its recommendations to the Office of the Superintendent of Bankruptcy. And if approved, then you get your license as an LIT, Licensed Insolvency Trustee. Normally, there's some qualifications, such as you have to stay with your existing employer or a different approved employer for 2 years after getting your license, and then it becomes an unqualified. If you're looking for a bankruptcy trustee, how do you go about finding one? Well, there are 3 ways that we recommend. First, and the best way, is to get a referral from a friend or a family member. Now, that friend or family member may or may not have gone through a bankruptcy or consumer proposal. If they have that personal experience, then that is the best if they're willing to recommend the trustee they went to. Or they may know someone, a good friend that they trust, who is a licensed insolvency trustee, or they may know a lawyer or an accountant who has had dealings with one or more bankruptcy trustees and is prepared to recommend one or more of them. That is the best way, a personal reference. The second way is you can go to the Superintendent of Bankruptcy's website, and they run a database of all licensed insolvency trustees across Canada. You can search by name, by city, by province to find one or more names. And the third way is by doing an online internet search. Search for words like bankruptcy trustee near me, bankruptcy trustee, and then the name of your city or town, and see what comes up. Then you could scour the several websites to see which ones kind of hit you, make you feel the right way, and then you can make an appointment for a no-cost consultation to make sure that the recommendations you're getting make sense to you and that you get a feeling that you can work with that bankruptcy trustee. The final question we are always asked is, how are the fees of a bankruptcy trustee calculated? Well, it depends on what kind of administration. In a summary administration bankruptcy, which is a personal bankruptcy where the assets are not expected to realize more than $15,000, or in a consumer proposal, the fee is set by the Bankruptcy and Insolvency Act. The rules of the Bankruptcy and Insolvency Act say that the fee of a trustee, either in a summary administration personal bankruptcy or in acting as administrator of a consumer proposal, are fixed. It's called a tariff. So the trustee can calculate its fee and disbursements based on the tariff, the regulated fee set by the Government of Canada. If there are not enough assets in the bankruptcy administration, the trustee will ask the debtor to get a third party who will either guarantee the trustee or the consumer proposal administrator's fee or put up a cash retainer. In an ordinary bankruptcy, which is where the assets are supposed to realize, anticipated to realize more than $15,000 in a personal bankruptcy, or for every corporate bankruptcy, or in a Division 1 Part 3 proposal, which is for people who owe more than $250,000 other than for any mortgages registered against their home, or for any company, either bankruptcy or proposal, the ordinary bankruptcy administration or the Part 3 Division 1 proposal area applies. In that case, it's like going to a lawyer or an accountant. It's basically the number of hours spent by each level of staff at the bankruptcy trustee firm at their respective hourly rates. In either an ordinary administration bankruptcy or in a Part 3 Division 1 proposal, ultimately the bankruptcy trustee's fee has to be approved by the court. The court will review the fees being charged and make a determination whether it's reasonable or not. Again, if the trustee does not believe there will be sufficient free assets to pay for the administration, the trustee will ask the debtor to get a third party who will either guarantee or put up a cash retainer for the fees. In a receivership, it's the same thing, number of hours, hourly rate by each level of staff. In a private appointment, the fees have to be approved by the secured creditor who appointed the receiver. In a court-appointed receivership, again, it is the court that has to approve the fee and disbursements of the receiver. So I hope this video helps you better understand what a bankruptcy trustee is, how you become a bankruptcy trustee, and how the fees are calculated in the various administrations a bankruptcy trustee can do, and what the different roles a bankruptcy trustee can play are. I encourage you to read the entire Brandon's blog down below, which has a lot more detail in it than I put on this video. Again, the Ira Smith team hopes that you and your family are safe, healthy, and secure. Both Brandon Smith and myself are available to talk with you on the telephone, meet with you via video chat, to answer any question you might have about this Brandon's blog or anything else. So shoot us an email message or give us a phone call. We would love to speak with you. We would love to help you.